Good afternoon and welcome to the Hall of Justice for the first day of the Michigan Supreme Court April case call. We will call our first case in re Green. This is a 20-minute grant. Welcome, counsel. You may reserve some of your time if we do not use it up, and we ask that you do your best to keep track of your own time. And you have 2 minutes of a free fire zone if you wish, or you may waive it.
Chief Justice Clement and Associate Justices, good afternoon. May it please the Court, my name is Michael Ashcraft, and it is my privilege to represent Judge Tracy Green. If I may, I would like to reserve 5 to 8 minutes of my allotted time for rebuttal. The JTC has asked that this Court remove Judge Green from her elected position as a judge of the Third Judicial Circuit Court. The request comes following a lengthy proceeding, a proceeding that was flawed and in which Judge Green was deprived of due process and fundamental fairness. The questions before you this afternoon all have at their core the serious issue of child abuse. In this proceeding, the JTC has conflated corporal punishment with child abuse. They are not the same. Corporal punishment is legal in the state of Michigan. Child abuse certainly is not. Corporal punishment, while legal, is a highly sensitive issue, one that is morally accepted or rejected across a broad spectrum. While controversial in some communities, cultures, and faiths, it is perfectly acceptable and even expected in others. The Commission has placed its imprimatur on Discovery Counsel's recasting of counts 1 and 2 of the amended complaint in this case. There are no foundational proofs supporting the actual counts and charges remaining against Judge Green. The JTC charged Judge Green with 3 counts, 2 of which remain: covering up evidence of child abuse and making false statements about child abuse. The complaint and amended complaint are specific in those charges. Child abuse is a legal term of art in Michigan. It is a crime that requires specific elements of proof. The JTC complaint and amended complaint charges are premised on that foundational element of required proof, the existence of child abuse. During the course of this matter, however, the words child abuse were replaced by the JTC with the word abuse. Abuse is a general and nondescript word that, in the context of a formal legal proceeding, even an administrative proceeding, must be defined by some standard or elements. It was not defined in this matter. Child abuse must be more than a mere accusation. The Commission has failed to cite record evidence of child abuse. The Master acknowledged in her report, as adopted by the Commission in its decision and recommendation, a finding that whether child abuse did or did not occur would not be decided in this case. The Master stated in her report, quote, "The Master will henceforth refer to specific alleged acts without making a determination about whether they legally constitute abuse, as such a determination is beyond the scope of the Master's authority." The JTC has disregarded that proof that proving child abuse is a foundational element of the pending charges. The Commission now cites to no proofs of an incident of child abuse, no who, what, when, how, where, or why. No evidence before June 24 of 2018. That is significant in this case because on June 24 of 2018, Judge Green's grandsons were removed from their home in the custody of their father based on allegations of child abuse. The Commission does not cite to a single police report no CPS files opened, no CPS report, no mandatory reporting by CPS, a school district, a teacher, a church, or a church ministry leader. No photographs, no medical records, no videos, no hospital visit, no doctor visits, no kids talk interviews, no expert reports, no formal criminal charges.
Counsel, what's the significance of Judge Cox's order prohibiting the use of corporal punishment?
Indeed.
In 2015, correct, the order?
Yeah, the order was actually 2015, that's right, Justice Kavanaugh. But the issue here was not whether there was use of corporal punishment in violation of a domestic order in a domestic relations case. The charge against Judge Green here is that she was aware of child abuse, covered it up, and then made false statements about it. Not whether or not there was a violation of a no corporal punishment order. That's the conflation, respectfully, by the JTC of the concept of corporal punishment being inextricably intertwined with the concept of child abuse. They're separate things.
How do we deal then with the actual September, I think it was September 2019, the actual juvenile court hearings where she testified? And I think the JTC has taken the position that the testimony conflicted with answers they gave to their JTC investigation.
Yes, Justice Welch, thank you for that, because it's a very important point in this defense. Judge Tracy Green was a lawyer for decades before she was elected to the bench. She was a lawyer in the child welfare space. She represented families and children. She practiced in the juvenile court system. She understands exactly how it works. Yes, she's a tactician when it comes to her language. So when she was asked on cross-examination during the juvenile court hearing whether she put makeup on a bruise on either of these boys, the answer was, first answer was, I never saw a bruise. And then the cross-examiner pushed her, answer the question as phrased. She said no. She did not apply makeup to a bruise on either of these boys. And if I get to it in my argument a little bit later, I'll be able to explain, Justice, that there was one admission that she did put makeup on a red handprint left on the cheek of one of the boys. In fact, she was the one, Judge Green, that told CPS about that, about the slap. She communicated that information. She's never backed down from that. The JTC recast the charges against Judge Green and focused on alleged corporal punishment in violation of a civil court order. An order was entered in the custody trial in 2015. The commission states that Judge Green was aware that her son was violating that order by using corporal punishment on her grandsons. Judge Green acknowledged that she knew about the no corporal punishment order, but did not state that she was aware of the order being violated. There's no evidence in the record that Judge Green knew her son was violating the order. There was no finding in this matter that her son was violating an order. Regardless, and even assuming that there was, Judge Green was not charged in the amended complaint in this case with having such knowledge and not reporting it. The commission has not cited to any authority that required Judge Green to report her knowledge of the violation of a civil family court order, even if she had knowledge. Because the allegations of child abuse could not be substantiated, the commission then recast the charges through disciplinary counsel against Judge Green. They recast the charges from covering up evidence of child abuse and making false statements about her knowledge of child abuse, which are counts 1 and 2, to covering up evidence of corporal punishment in violation of a civil family court order and making false statements about her knowledge of same. Here the commission attempts to connect the false statement charge by saying that Judge Green knew about the violation of the family court order. There's no evidence in the record that she was aware of any corporal punishment after entry of the 2015 order on no corporal punishment. With regard to the pinkish handprint, the pinkish handprint was not child abuse. If there was no finding that the alleged acts of which the boys testified legally constituted child abuse, there can be no finding then that Judge Green was aware of, covered up, and then made false statements about child abuse. There's no dispute that Judge Green notified CPS of the slap to her grandson's face, the slap that left a red handprint. There was no CPS investigation or report about the slap, and there were no charges filed related to the slap. The master, however, went to great pains to convert the red handprint caused by the slap into a bruise, and the commission adopted that finding. The grandson who received the slap to his own face testified during the public hearing that it was not even red and was in fact, quote, pinkish, close quote, and went away. But the master, through the use of different dictionary definitions, attempted to turn that pinkish handprint into a bruise. Why? Because when you get to bruising, there are issues of child abuse. Those definitions are not even in the record. Despite the fact that these sources are outside the record, there is no evidence in this case, testimony, documents, or otherwise, that supports any of these definitions. Even the testimony of Judge Green's grandson himself did not.
Counsel, can I direct your attention in the time we have left to the issue of the sanction? The JTC is seeking removal, and I don't read your client's petition as challenging, if we disagree with your arguments of the finding of misconduct, I don't see an argument that you have made that the sanction of removal is improper. Do you concede that if we disagree with you and find that the misconduct is substantiated, that removal is the proper sanction?
No, I do not, Justice.
What do we do with the fact that we don't have an argument from you about that?
Because of limited space, candidly, it wasn't included in there, but it was something I prepared to address this morning under the Brown factors, or this
Okay.
afternoon under the Brown factors.
Can you address why, assuming that we disagree with you and find the misconduct substantiated, why removal is not the proper sanction, and what would be a proper sanction in your estimation?
Understood. Thank you. Under the Brown factors, and we know that there are 7 of them, assuming arguendo that there was a violation of the canons and a violation of the Michigan court rules, misconduct that was not, this was misconduct that was not a pattern or practice. It was not misconduct on the bench. This is something that occurred before she was...
On the pattern or practice, what about the allegation that these marks had been left on the boys on more than one occasion, and that your client had applied apparently makeup to the boys on more than one occasion?
The only testimony, Justice Viviano, that came in with regard to that was from the boys themselves. There was no objective evidence of any sort.
Well, what's wrong with their testimony?
Nothing's wrong with their testimony, but if we compare and contrast the testimony over the course of the multiple interviews by law enforcement, Kids Talk, even disciplinary counsel, we can see that the testimony changed each time they interviewed. And that's why our expert, Nancy Deal, who's a stipulated recognized expert in child welfare and the forensic interview protocol, testified that she wasn't aware of any case where someone was prosecuted for child abuse as a result of a slap and a handprint. There was no other evidence.
You're sort of going afield. I think the finding by the master was that this had occurred on more than one occasion, contact leaving marks that were then covered up by your client. And so my question is, one of the concerns, obviously, one of the charges is that your client only acknowledged seeing marks and applying makeup to cover up those marks on one occasion. So I wanted you to address that, because that's, I think, a critical point.
Understood. Justice Viviano, it was testimony that was given that was inconsistent between all the other testimony given by the boys during interviews, on the record, during different court proceedings and the like. That doesn't, in and of itself, make it not credible. However, when you consider the other evidence...
We don't sit as the fact finder, right? There was a hearing before a master, and we have to give some confidence or some, to the findings of the master, unless there's no evidence at all to support them, right?
The only evidence in the record to support more than one mark, that being a pinkish handprint left on a cheek, came from the boys when they testified. That's the only evidence. The problem, and I understand that you're not sitting as a fact finder here, but you are sitting to decide whether or not Judge Green received due process and fundamental fairness in this proceeding. And when you look at the master's report, including the decision and recommendation by the commission, there's no citation to Nancy Deal, the only expert in the case, no citation to her testimony, no citation to the testimony of the family members of Judge Green who saw the boys as often as she did, who indicated they never saw any marks on their bodies. The school teachers who we brought in specifically and asked, they being mandatory reporters, if they saw marks, they all testified they never saw any marks. We brought in the church ministry leaders, where the boys went every week as youth and participated in choir and youth activities. Each of those, 2 of them testified. We saw them all the time and never saw any evidence of child abuse or marks on their bodies. So the issue is one of weight and credibility. Respectfully to the master, we don't see that she considered the evidence that was introduced in the case by Judge Green, some of which I just cited.
Thank you, counsel.
Thank you. Justice Kavanaugh, shall I continue
Please.
with it? Thank you.
I apologize.
On the Brown factors, number 2, it was not misconduct that was on the bench. Judge Green took the bench in January of 2019. Number 3, this was not misconduct that was prejudicial to the actual administration of justice. There were no proofs introduced in the record that demonstrated that there was a connection between those 2 things. Number 4, misconduct that does not implicate the actual administration of justice or its appearance of impropriety. The same answer there with regard to it not being a matter that was addressed on the bench. Number 5, at worst, this was misconduct that occurred spontaneously. Judge Green responded to 2 specific questions that were cited by the commission. One was the juvenile court testimony that I just recounted for you, where she tried to explain in taking apart the question as she was asked that there was no bruising that she had ever observed. And number 2, the interview with the investigative reporter who asked the same question. Did you put bruises to cover up a mark on someone's, or did you put makeup to cover up a bruise on someone's face? Those were spontaneous responses. It's not a situation where she stood back, took her time, and tried to figure out how best to craft a response that would insulate herself from some sort of liability or culpability. Number 6, this was not misconduct.
Can I interrupt just real quick? I just want to make sure that you're aware of your time. You asked to reserve 5 to 8 minutes, and you've only got 2.5 left, so.
Understood.
Yeah,
Thank you very
yeah.
much. I will reserve then the rest of my
Okay,
time.
thank
Thank
you.
you, Justice Clement.
Good afternoon, Chief Justice Clement, and may it please the court, Mark Magyar on behalf of the Judicial Tenure Commission. The JTC, as the court knows, is asking for removal based on a finding that the record did support by a preponderance of the evidence the misconduct charged in counts 1 and 2 of the formal complaint. Those charges are that the respondent knew about and concealed evidence of child abuse to protect her son, and that when it came to these proceedings, she lied about having done that to protect herself. And before I go into, I guess, my planned remarks, I want to just briefly address that we are not in a civil or a criminal proceeding, and that's clear from this court's decision in re Ferrara rejecting the notion that these proceedings are even quasi-penal. These proceedings are concerned not with punishing criminality, but with maintaining standards of judicial fitness. So respectfully disagree with the argument that there has to be some sort of finding of child abuse as that term is understood in the criminal law in this administrative proceeding where the respondent is not accused of committing a crime in order to find that the respondent, quote, engaged in conduct prejudicial to the proper administration of justice, engaged in conduct that exposes the profession to contempt, such a reproach. The court is well familiar with the types of misconduct that that the JTC found were committed here. They don't include committing a crime. In fact, the JTC expressly rejected the disciplinary counsel's assertions that some of the misconduct was violations of criminal statutes. In that regard, this notion that expert Deal found that one single slap mark is not child abuse is a red herring, because that would only be relevant if we're talking about what respondent's son did. We're talking about, did the respondent have reason to be concerned that she was aware of evidence of child abuse?
Counsel, I want to ask a question. I know we've got a lot to cover here,
Yes.
but one of the things that I was a little concerned with was this question of in person, right?
Yes.
And how do I read into that? I mean, the issue here is you're asking for this person to be taken off the bench. You're asking for them to be stripped of their, of their profession. How do we look at that as it pertains to when the consequence is so great? How do we address the in-person component that, like, using Zoom or technology, when basically this is a trial that's going to determine someone's entire livelihood, their entire professionalism, and for all intents and purposes, kind of their overall fate?
Thank you, Justice Bernstein.
Please.
And I do want to address that for several minutes, if I may. The starting point, I think, is with this court's decision in the Morrow case, the 2020 case. And this
Right.
issue came up in the fact that I think Morrow, in this case, and I'm not sure of many others, there were only a couple that happened right during the pandemic that
Right.
necessitated some virtual proceedings. And the majority in Morrow declined to go all the way to find whether MCR 9.231B requires an in-person hearing or not, and found in that case, because Judge Morrow did not dispute the facts of the case, that there was no prejudice or impairment of justice, and so the proceedings were valid under MCR 9.211D. And Justice Viviano, you authored a concurring opinion in that case saying that you would have found that there was a violation of the court rule for not having it done in person, but that the proceedings were still valid for that reason, that there was no impairment of the administration of justice. And I think, to answer your question directly, Justice Bernstein,
Yes.
I think that's how you have to look at the situation. It's fact-specific. And if the court were to go all the way to find a violation, as Justice Viviano promoted in his concurring opinion, that doesn't end the inquiry, and it's not going to be something that you can apply to every case. And I think that's the mistake that the respondent makes here in the petition on page 11, where it kind of sounds like a de facto argument that if you make a credibility determination and you were on Zoom, you have a structural infirmity that gives me a new hearing. And the petitioner also says on page 10 of their petition that if you have Zoom, you could be looking side to side, there could be others in the room, you could be looking at documents. But what I think the petitioner in this case, the judge fails to do after that, is to indicate how that happened here, when and where. Because
Counsel, you raised my concurrence in Morrow, so I think it's only fair to point out that I noted there, in fact stated, most significantly, nearly all the pertinent facts in this case, meaning Morrow, were undisputed. And of course here, as we just heard from counsel and have seen throughout the briefing and arguments in this matter, the key facts, at least the facts that I think are the key facts, are very much in dispute. So wouldn't this take this case outside of my concurring statement in Morrow?
I don't think it does, Your Honor. First of all, let me agree.
I mean,
totally.
the credibility of the boys, largely, your case largely rests on the credibility of their testimony. Is that true?
No, I don't think so. I think it puts it from a preponderance of the evidence based on the other evidence I hope to have time to go through, and takes it to not even a close case. I wouldn't dispute that it is strong evidence in this case. But the reason I don't think, and we acknowledged in our petition, or our reply to the petition, and I'll freely acknowledge now, that what you've just said makes it a different factual case than Morrow, in that you had no disputed facts, now you have essentially disputed facts that were elicited via Zoom, and there was a credibility determination. I will grant all of that. But then we get to...
In most other proceedings, and you've astutely pointed out this isn't a criminal case or a civil case, or like those things, but in those types of proceedings, we wouldn't allow evidentiary hearings and testimony under oath to occur by Zoom, would we? I believe even in our rules that allow lots of Zoom in lots of circumstances, many of which I don't agree with, I think we stopped short of saying, allowing courts to make factual findings based on virtual testimony, unless all the parties are in agreement with that.
I'm not sure what this court would allow. I don't have a specific case in front of me. I know we cited some outside of jurisdiction cases looking for some authority where these kinds of things happened, and minor's testimony that wasn't in person was accepted. I think there was a Connecticut case. I'm not sure, to answer your question, what this court would allow in other cases. But I think under your
Well, let me say it this way. I mean, I assume you recognize, and we all, as we all must, I mean, there's constitutional confrontation clause reasons too in the criminal realm, that it's better to be in person than it is to be on a computer screen when we're trying to determine a witness's credibility. Would you agree with that?
I do agree with that. It is better. And that's why I sort of want to give a few more comments, if I may, on the impairment of the proceedings, the miscarriage of justice, as opposed to whether it was a violation of the court rule or not. Because I think in this particular case, there is a lot of room for a lot of reasons to say that even if you found a violation of the court rule, that for different reasons than in Morrow, that there was not a miscarriage of justice. Some of those reasons being ample opportunity to cross-examine. The master's report even noted how exhaustive the cross-examination of these minors was. Another reason is that, I personally, for the second time preparing for today, reviewed videos of the interviews that are exhibits to the hearing. I think Russell, the one grandson, is exhibit 46. There's several other exhibits. And when reviewing those, as the court either has or I'm sure will before rendering a decision, to me makes the arguments really become academic and show that this isn't a case to flush out the potential concerns for Zoom, because there's no indication on those videos, there was nothing asserted during the hearing, and there's nothing asserted in the petition that the concerns attendant with the imperfect Zoom proceeding actually occurred in this case. I saw disciplinary counsel Weingarten interviewing Russell. I saw her interviewing Max. And we don't see these children looking to someone other than the questioner, or getting out a cell phone, or getting a document. The master in this case provided an order in May of 2021 when she denied the motion for in-person, setting forth numerous safeguards for what you can't do and what you have to certify on the Zoom record that you're not doing, which is anyone else that's not there, or no one else can be there. The questioner has to identify themselves. You can't use any document. You're limited to the exhibits shown to you for the hearing. All of these things that were put in place, which I'll grant is not 100% foolproof safeguard that someone won't violate those, but there's no reason to assume any were violated, and there was no assertion during the hearing or in the petition that they were. And it seems like the petition at pages 10 to 11 argue more about the potential pitfalls of Zoom rather than anything that happened in this case. So I don't think this is a great vehicle to pronounce that you can never have a credibility determination made on Zoom, where you look at these videos, these children, these victims of their dad's abuse, are front and center. You can read their demeanor, you can read their body language, and they are telling anyone that will listen that my dad beat on me. I told my grandmother every time I got a chance. I was happy when we got taken out of there. I didn't want to go to my grandma's because she knew what was going on and she'd let me go back to the person I'm afraid of. These videos, like I said, make these questions more academic in this case than practical.
Counsel, can I direct you to the question of sanction?
Yes.
And I understand that you take the position that this was conduct that occurred on the bench. Let's assume that I disagree with you about that. And I know that, as you know, and we know from all of these cases, that a fair consideration of the degree of sanction can be, the issue of how repeated the misconduct, how many incidents of misconduct, and particularly when it relates to on-the-bench conduct. What are we to take from the fact that this is, maybe there were repeated incidents, which is disputed, about the mark on the face, but looking at this as really a single sort of issue of misconduct. And there do not appear to be any prior instances or other instances of judicial misconduct of Judge Green on the bench, of how she runs her courtroom, of how she treats, litigants and lawyers and staff and all of these things that we see. Can we equally take into account the lack of other evidence of misconduct in determining whether the sanction you're requesting of removal is actually appropriate?
Thank you, Justice Kavanaugh. To briefly answer your question, I think the court is permitted to consider whatever it wants to consider. I don't think the Brown factors are necessarily exhaustive, and I think that if there's anything this court feels pertinent, weighs in on the appropriate sanction, then it would always be appropriate for the court to consider it. Now having said that, I'm not sure that I agree that finding that it was so isolated would be the right finding for a couple of reasons. One is there was separately, while she was on the bench, a prejudice to the actual administration of the juvenile proceedings, and I think that's a key problem when you're withholding information and sort of minimizing and limiting to only as much as you've previously said before about one instance. That prejudiced the juvenile proceeding under oath while a judge. Now, certainly not on her bench. But also, she testified in the juvenile court and doesn't dispute that for a 3-year period, while she was a family law advocate, her son had exclusive custody of these boys that she would see on a weekly basis, have overnights once a month, that they, quote, had a bond and confided in her. That's the respondent's testimony in the juvenile court. And
Isn't that was admittedly pre-bench conduct, right? And I think in your report, the JTC acknowledges that if that were the only issue, that a sanction of removal wouldn't be appropriate for that conduct. So we're talking about the misrepresentations on the record of this particular instance, right? There are no other, and I know the JTC from prior cases and from that to be very thorough, that there aren't other instances of misconduct of Judge Green's temperament, ability, of performing her job as a judge. And so what are we to make of that?
I think where I was sort of going with even the pre-bench conduct is that when you enter the realm of under oath dishonesty, you're entering into a new realm under the case law. That is, there are quotes that I won't get exactly right without it in front of me, but that sort of misconduct is so directly bearing upon the fitness that and in fact, In re Adams is one of the cases where the JTC recommended a less than removal respondent, and this court came in and rejected that for the more harsh discipline of removal because the lack of fitness tied to making false statements under oath. And I
But
would
there's
say
also
even
the Simpson case, right, which is post-Adams, where there was an intentional misrepresentation where the JTC requested removal, and this court removed or suspended for 9 months. I mean, so I get it, that it's not the easiest sort of looking at this court's history of how to, fashion a sanction. But so there's evidence for, obviously, a very serious, egregious misconduct of lying under oath, right? So there's evidence of removal, sort of a hard line removal for that in some cases. But there is also, this court has also taken a less than a hard line removal. Why is that more akin to Adams in that line as opposed to, something, and again, I sort of focus on the lack of other evidence outside this context, this one particular incident, I say. What's the sanction for why it's closer to a hard line removal?
Thank you. I think it is, in this respectfully, Your Honor, I think we're much closer to the Adams side, because I remember reviewing Simpson for the last case that was in front of the court, the Judge Davis case, and I remember taking away from that there were some, and I don't want to misrepresent the holding, and we can all go back and read the case, but I remember there being an element to that single representation that was somehow understandable. It was either not as willful or maybe more prone to be mistaken, or maybe that they're out of the misrepresent. This is what it was. The false representations that were intentionally false were not under oath. And the only one that was made under oath, the court wasn't convinced was an intentional
Was intentional.
misrepresentation. So I think here what we have is the intentional under oath misrepresentation that takes you out of Simpson, puts you directly into Adams and the whole line of cases.
Can I ask a follow-up on that?
Sure, yeah.
Are you talking about, some of the charges are based on what the written response is, and some are, or another one is based on the testimony before the master, is that right?
Yes,
But as I understand it, the complaint, which was amended in this case, but it was amended before the testimony before the master occurred. In other words, there wasn't an effort to amend the complaint again to include these charges, which is the procedure that we talked about in Simpson in footnote 20. Is there a reason why the complaint wasn't amended so that the respondent had notice and could respond to the charge that she lied during the hearing?
Your Honor, I think without being completely familiar with that aspect of Simpson and the procedure noted, I think I've certainly been involved in more than one case, and that's not to say that it's right or wrong, but where by the time you get to the hearing, certainly you could do a post-amendment hearing, but leading up to the hearing, you can't allege for someone lying at the hearing. And I think that that's an independent basis at this stage of the proceeding when that additional misrepresentation occurs. If I'm wrong about that, I'd be glad to go into what we think in terms of the sworn statements and the answers that also comprise that count. But to answer your question,
Well, it's clear the complaint can be amended at any time, that's what the rule says. And this footnote, I think, surely suggests that that's the proper procedure to follow, because that gives the respondent notice of that additional charge at a time when, if there needs to be evidence, for example, taken to respond to that charge, the respondent can still do that. That's the whole idea. It's why we don't charge somebody with perjury in the same case where they testify, right? Because it's a separate charge which you're allowed to defend yourself against.
the only thing I would say, Your Honor, because again, I don't want to speak without knowledge on this, the procedure that you're referencing, but I would say that in this particular case, there isn't anything different being said. She basically stayed the course of her answers that we say then became another under oath false statement, not, oh, and gotcha on this new false statement and gotcha on X, Y, and Z false statement. It's a carryover of the same position that didn't change and was communicated at the hearing. So I think even by petitioning this court, there was an opportunity to address that on this petition for review.
So let me just ask you the question, I think you've sort of addressed it already, but if we reach the conclusion that, you know, for whatever reason, we're uncomfortable with the Zoom nature of the proceedings or the lack of an amended complaint, or for whatever other reason, that we're not willing to sanction the respondent based on the testimony, her testimony at the hearing, do you believe her responses, written responses to your, the JTC's request for comment are sufficient to warrant her removal from the bench?
I do, Your Honor.
Can you explain why?
Yes. And I realize I'm out of time, so I won't sort of abuse the question with going too long and answering it. But
Let me just say, this is an important matter, and I'm happy to hear from you, and I'm going to give opposing counsel some additional time as well. This is a pretty significant matter.
okay, well, thank you for that, Justice Rubiano. The reason I think the answers themselves are sufficient to find lying that deserves removal is because when the master looked at the record of the whole and the JTC deferred to those credibility findings and also on a de novo review agreed with those findings, is because it found a concerted effort to unsuccessfully paint around some very careful lines. The wording, as the master found, was intentionally vague and invasive and used a mastery of language in order to, only answer as close to the question being answered. And the respondent even takes, I think, some pride in that in the petition that, we did some excellent litigation drafting here, and if you wanted a better answer, you should have written a better question. And I think that misses what these administrative proceedings are for under MCR 9.202B1F and MCR 9.221E. The respondent has an obligation to cooperate with the investigation. This isn't some high money antitrust case or patent case. The goal isn't to be technical and draw fine line hair, like split hairs, so that you can deny something between whether something was a slap or a bruise without elaborating.
I've always been a little sensitive to the notion that people aren't allowed to defend themselves before the JTC. In other words, not allowed to put whatever happened in context or explain it from their perspective. I'm not excusing anyone's behavior in this or any other case, but it does seem kind of fundamental to our judicial system that people have the right and the opportunity to provide some context and cast whatever occurred in the best light from their perspective. Isn't that sort of the nature of the proceedings?
Yeah, and I think that would have, exactly, I think that would have been called for. And instead of narrowing the answers to be sort of short and vague and deny, and only find out later that the reason you denied is because you disagree with the characterization of a bruise or a slap, I think it would have been both helpful to the respondent and the JTC to flesh that out and have the opportunity to explain in a more fulsome answer of what exactly the reason for the denial was and the distinction being made. You know, to conclude the answer to that question vis-a-vis the sworn answers we got, at this under oath juvenile court hearing, the respondent testified to, as well as the CPS investigation, the things that were later changed after the fact in the answers initially started out with unequivocal, I was aware that Gary and Russell were disciplined with a belt. Page 65, juvenile court proceeding. She agreed. Children told her in the past they would get spankings, but never asked what a spanking was. Page 65. Agreed that she considered her son a stern disciplinarian. Page 65. And all of those things happened in the context in real time of the June 24, 2018 arrest of her son over physical abuse. No, there was no question. Everybody knew what we're talking about. When they had a 3-hour family team meeting with the CPS investigator, nobody's talking about 4 years ago from before the divorce court order. No one's talking about non-physical punishments of taking video games away or being sent to your room. Everyone's talking about physical abuse. But then when she gets trapped in these admissions in this investigation, she's not thinking about being investigated by the JTC at this time. When it comes to being trapped in these admissions, she's got an answer for everything. That's what the master found. That's what the JTC found, is when I said past spankings, oh yeah, I meant before the corporal punishment order. When I said I knew that she got hit with a belt, or he got hit with a belt, I meant that I didn't actually have personal knowledge of that. I learned about that through CPS and through these judicial proceedings, not that I knew about that in real time. When I saw the smack on my grandson's face that was so prominent that I, as a grandmother, put makeup on him, I didn't think that that was evidence of abuse. These are all explained away, as the master put, plausible deniability. We weren't required to believe those implausible explanations, and neither the master nor the JTC did believe them.
Thank you, counsel.
Thank you.
Thank you, Justices. I'm very sensitive to my time issue, but so that we're clear, I don't think there's a dispute here that the JTC process is adversarial. So when a judge is in the crosshairs of a JTC investigation, he or she will most certainly be very careful with their words, very circumspect, very specific to the questions asked. Brother counsel just raised a specific issue, and that was during a family team meeting, she acknowledged being aware of the children being spanked with a belt. Interestingly enough, there's no proofs in this case that support that. But even assuming arguendo that there are, respectfully and sensitively, corporal punishment is not illegal in the state of Michigan. Spankings are not illegal. And when you consider the cultural aspects of it, it's a broad spectrum of what is accepted and what is not accepted. But there were never any charges about that. The burden of proof is an important point here, and I'm not here to say it would be a different forum where we would have to address the issue of whether preponderance is the proper standard for judicial tenure commission proceedings. But in this case, the first consideration has to be the one that the evidence would be considered in if it were a crime. In the amended complaint, the the commission specifically cite statutes, criminal statutes. Well, that's a beyond a reasonable doubt standard. So the approach that should have been taken by the master in this case was to determine first, beyond a reasonable doubt, whether there was or was not child abuse, and then move on to the preponderance of evidence standard to find out whether Judge Green was aware of it, covered it up, and then lied about it. That never happened.
Counsel, I want to give you another opportunity just because I don't think you got the chance to do it when you were up here before. Assuming we disagree with you and find that there was misconduct, what sanction short of removal do you feel would be appropriate?
Thank
And
you.
why?
Thank you, Justice Kavanaugh. Under the Brown factors, I think we've articulated the details of that, but we have a single event here on a family matter. We have opposed the removal standard since the beginning when we were told what was going to be sought from this court. But in this particular case, the only thing that it can connect to was this juvenile court hearing. Well, the juvenile court hearing specifically was on a matter where the kids had already been removed from their father's home. How could anything that she did say or did not say be prejudicial to the administration of justice? It couldn't be. And in fact, shortly thereafter, the father was convicted of felony child abuse and sent to jail. There's nothing that the Judge Green did or did not do that related to the juvenile court hearing that in any way had an impact on the administration of justice. Nothing. So, Justice, I think that at worst, assuming arguendo that these allegations are true, it's a family matter. She was being sincere. She was being succinct and direct in answering her questions. She didn't deceive. That would be something that would be appropriate at worst to be a censure.
Thank you.
May I continue with my closing?
Yes.
Thank you very much. Just 2 additional points, if I may. The issue of in-person proceedings. Now, this is a significant issue, and we raised it in the underlying case, as you know. But everything in this case hinged on the testimony of 2 boys who at the time they gave their testimony were 13 and 11, testifying about a removal from their father's home when they were 10 and 8, and then testifying about events that happened when they were even younger. Now, one of the boys, the youngest, was at his mother's home, testifying from his mother's living room. We know from one of the videos that's been admitted into evidence that there was a vitriolic relationship between the mother and Judge Green, her former mother-in-law. She said horrible things about Judge Green in those YouTube videos. The boy is testifying from his mother's house. There's no way to assess weight and credibility. There's no way to properly cross-examine the boy in that setting. I say that respectfully. The second boy, the oldest one, he testified from the offices of the commission. He was picked up by commission staff, brought in, taken back home. He was given lunch by the commission staff. On the 3rd day of his testimony, there was an explosive event where he got very upset. He was comforted by commission staff. How is that considered an independent opportunity to confront your accusers and properly cross-examine them? I respectfully submit that it was not. And then finally, we respectfully request that the court reject the decision and recommendation of the commission and dismiss the amended complaint against Judge Green. Thank you.
Thank you very much to both of you. The case will be submitted.
Thank you. Good afternoon.